Good morning. Y'all miss business law? You can be honest. It's okay if you didn't. It was a nice week off, I'll say that. Anybody have any questions? All right, so we're back to same schedule that we're used to. We're going to do a new topic this week. We're going to start tort law, and then we're actually going to do this for 2 weeks, but you'll have a quiz based on this week's lecture and readings, and then you'll have a discussion question this week, and that's all for this week. Then we'll do part 2 next week. It'll be the same deal. So we're rocking along. Anybody have any questions about their final exam project? Everybody make some progress on it? Okay, good. Good. I don't want us to get to the end and y'all be stressing out or having to cram to finish that. So I'm glad you got started on it. Anybody have anything to share this morning? More dirt on who? What is it?
We have 3 locations.
Okay.
Here the Halo and
More dirt on Dan.
he has a paid kid $1,000.
Shorted somebody $1,000, huh?
So he was owed 600 at Halo. Still hasn't gotten that. He's owed like 4 or 5 here. Still hasn't gotten that.
What's the holdup?
And also, one of the best zipline guys. She was one of our main team leaders. She applied for the assistant position. A lot more money.
Yeah.
Compared to what we make. And he said, "Oh, I'm not a good fit. They have a lot of managers."
What's she gonna do about that? Have you?
She said, "I'm either leaving or you're giving me this position." Because I mean, she has to
Yeah.
say that because she's worth at least.
Have you been representing her? You giving her legal advice?
She's gone. She's already left. Like,
You want her job?
no, I had the same job as her.
Okay.
Me and 2 other guys, or me and 2 other guys had the same job as her. We both went to college right now. We all 3 of us were the top ones basically, and she wanted to move up to the assistant manager.
But it sounds like Dan has no incentive to treat people right because everybody just quit and move on, I guess. Or
Well, if they don't get a raise,
nobody ever really challenges him or anything.
people challenge him all the time
He just wins.
because he basically owns Columbus.
Interesting. More dirt on Dan. Well, stay tuned for further episodes of that. I like this. We're going to bring him down. All right, so today we're going to get into tort law, which is a completely new area of law. We haven't talked about this yet. And I find that a lot of students, when we get to this unit, are like, "Professor, what in the world is a tort?" I mean, I've never really heard of that. And I identify with that because I got to law school and I was like, I've never heard of that. I have no idea what that means. But tort law is this area of law that covers private citizens who have wronged each other. So think about for a second, if I rob Caleb, I've committed the crime of robbery. I could be arrested for that. There's a remedy for him in the law. I can be held accountable on a criminal basis. But let's say that I push him down after class and he sprains his ankle and has to go to the urgent care and he has medical bills. I still might be arrested for some criminal activity on him. It is illegal for me to push him down and cause harm. That is a crime. But I also could be liable to him in tort law. Okay, so tort law covers this whole body of law that allows private citizens to get compensation from other citizens for wrongs that are done to them. Another reason that tort law is confusing is that a lot of torts and crimes overlap. So we can have an act that is both criminal and tortious. So it might fall under criminal law and tort law. So for example, if after class I punch Caleb in the face and he suffers a broken nose, I've definitely committed the crime of battery. But there's also a tort called battery as well. And the whole reason that tort law exists is to allow private citizens to get compensated for their wrongs, for a wrong that has been done to them by another. Caleb might need tort law in the example I just gave, because if I'm prosecuted or arrested or charged for criminal battery, then crimes are more interested in punishment of the person who committed the crime, deterrence, things like that. Criminal law is not as concerned with compensation of the victim. And so that's why he might need to sue me for the tort of battery as well, to maybe recover some damages that weren't available to him in the criminal prosecution. Also, I might punch him after class and the police might get called and they might decide not to arrest me or charge me with battery. He's not left out in the cold with no remedy. He can always sue me for the tort of battery. Car wreck cases, suing for injuries. Those are tort. That's along the lines of tort law too. Another example of the overlap between criminal law and tort law is the O.J. Simpson case. So when O.J. allegedly killed Nicole, his ex-wife, and her boyfriend, he was charged with murder, but he got acquitted for murder, found not guilty. Her family sued him for the tort of wrongful death. And her family won in the wrongful death suit. Tort law is entirely civil law, whereas criminal law obviously is criminal law. So that's another big difference between them. So knowing that O.J. was found not guilty for the crime of murder, but found liable for the tort of wrongful death, what would explain that? How could he be not guilty of the same act, not guilty of murder for the exact same act that he was liable for wrongful death? Who knows the answer to why that could be? What's one of the main differences between criminal law and civil law? You can have a jury in both. Close. What about the burden of proof? In criminal law, they had to find him guilty of murder beyond a reasonable doubt. Whereas in the wrongful death case, they just had to find by a preponderance of the evidence that it was more likely than not that he was responsible. So that explains that. Criminal law, we say someone is guilty, convicted. In tort law or civil law, we say someone is found liable. They're responsible. So we're talking about tort law today. We're going to talk about criminal law in a couple weeks, but today is just tort law. So I wanted to just point out that there are major differences between tort law and criminal law, but there is some overlap in some of the types of crimes and types of torts that we're going to study. So a big thing in tort law, obviously, is damages. If I push Caleb after class and he doesn't fall, he doesn't have any injuries, he might not sue me for the tort of battery because he doesn't have any damages to collect from me. All right? Plenty of torts go unpunished, but that sounds criminal law. Not every tort gets taken to court. The ones that get taken to court are the ones where somebody needs to get paid for the damages that they incurred. So different types of damages that I want you to be familiar with when it comes to tort law are compensatory damages and punitive damages. So let's break those down a little bit. Compensatory damages are exactly what it sounds like. These are damages that cover a quantifiable loss, like medical expenses, lost wages if a person has to miss work, the cost of repairing or replacing items. Think like in a car wreck. The compensatory damages might be medical expenses, lost wages from being off work, the repair cost to the car or the replacement cost to the car. Maybe I had a set of golf clubs in my car that were destroyed, maybe, and so I would want to be compensated for the replacing those. That's what compensatory damages do. Compensatory damages are not only just things that can be calculated, like a lost wage or the replacement cost of a car. They can also be for non-monetary harm as well. These are things like pain and suffering, disfigurement, loss of reputation, if we're talking about defamation, loss of a limb, loss of companionship or consortium, some kind of impairment. These are things that we can't calculate with a formula or numbers, but they're still compensable. And that also illustrates another reason why tort law is different than criminal law. Criminal law is just not going to get into things like pain and suffering of the victim. They're, again, interested in punishing the wrongdoer and that kind of thing. But in terms of, sometimes in criminal law, you'll see somebody has to pay restitution to cover the damage that they did. I mean, that is a form of compensatory damages. But these things like lost wages, pain and suffering, disfigurement, all those things they're not really part of criminal law. And so tort law is necessary for a person who's been harmed in that way to recover from the person who has wronged them. That's compensatory damage. They can be both specifically calculable and they can also be non-monetary as well. Then we get to punitive damages. Punitive damages are exactly what it sounds like. They are purely to punish the wrongdoer and ensure that it doesn't, and hopefully to not ensure that it doesn't happen again, but deter it from happening again. That's the theory behind punitive damages. Punitive damages are not going to be, if I push Caleb down after class and he breaks his arm and he sues me for battery and I got to compensate him for his medical bills and so on and so forth, he's not going to get punitive damages out of that. Those are reserved for egregious or just reprehensible conduct. And again, they're just awarded when we want to, when something is just so bad that having somebody pay compensatory damages just doesn't seem enough. The McDonald's hot coffee case. Y'all remember that? Y'all might be too young for that. But the lady that sued because she spilled McDonald's coffee in her lap, and she got compensatory damages for her medical bills and things like that. And then the jury awarded her punitive damages in a couple $1 million. And there was a bunch of outrage at the time that what is America coming to? This woman is drinking coffee that she knows is hot, and all of a sudden here she goes getting, millions of dollars from McDonald's. We're going to study that case next week, and it's actually a lot more. It's not as cut and dried as the media portrayed it out to be at the time. But that was a case where there were punitive damages. Punitive damages would also be more appropriate in the context of like a large company who's done something wrong. Even if I've done something really, really wrong to Caleb, the punitive damages they still wouldn't be that high on me because I don't have a lot of money to pay punitive damages. A jury could award him $2 million and he would die waiting to collect his $2 million from me. But if we're talking about a big company, then without punitive damages, what incentive do they really have to change their behavior? If all it costs them is a little compensatory damages here and there, they might be willing to take that on if it means that they're making more profits. So punitive damages can sometimes be used to really try to direct corporate behavior. We're going to talk about we're going to divide torts into intentional torts and unintentional torts. Unintentional torts kind of for next week. That's the tort of negligence. And we're going to focus this week on more intentional torts. As with everything we study, there are exceptions and there are defenses. So if I told you that, if I only told you that I pushed Caleb down after class and he broke his arm, and that's all you knew, then you might think that I don't have any defense to my conduct, that I've committed the tort of battery against him and I should be found liable for that. But if I tell you that he pulled a gun on me and threatened me and I pushed him down to get out of the way and run out the door, then that might change your opinion of whether or not I've committed a tort against him. So that would fall under something like self-defense. We're going to get into the defenses later on, but I just want to throw that out as part of our overview this morning. So let's start with intentional torts against persons. And this is following the outline that's posted as always. So intent means what it says, that a person meant to do the act that caused the harm. Now, that doesn't mean that if I didn't mean to do it, I'm off. We're going to get into unintentional torts next week. Being careless, reckless, negligent, that doesn't excuse someone from liability. But for this week, for what I'm talking about today, we're talking about intentional torts. I meant to put my hands on Caleb and push him down. I intended for the consequences of my push. Let's say that I push him down, or I push him, and he falls down and hits his head on that rail and gets knocked out and busts his head open and has a brain bleed or something. Would I have a defense that I didn't mean for that to happen? I just meant to push him. And so under tort law, the answer would be no, I don't have a defense to that. As long as I intended the act, then I'm going to be liable for the consequences of my act. So intent means I meant to do what I did, not necessarily that I meant to cause what happened. So we look at intent from the standpoint of what I meant to do. I can also, we also have something called transferred intent in tort law, which is that let's say that after class, I walk up to Susie and I intend to punch her in the face. And I take a swing at her and she ducks. And I ended up hitting Jesse in the face instead. I didn't intend to hit Jesse. I intended to hit Susie, but I ended up hitting Jesse. I'm still liable for the tort of an intentional tort in that case by transferred intent. I meant to swing and hit somebody. I just didn't hit the person I meant to. So transferred intent can also apply. The law generally assumes that one intends the normal consequences of his or her actions. So again, a push is an intentional tort because the object of what I push can be expected to fall, go flying, hit the wall, hit the ground, something like that. So that's how we look at intent and intentional torts. So let's talk about some specific intentional torts. Assault. We tend to think of assault as hurting somebody in the sense that a punch to the face or pistol whipping somebody, a beat down. We think of that as assault. But actually, assault has a different definition under tort law and criminal law too. But again, today's just torts. So assault happens when a person makes a threat of immediate harmful or offensive conduct that create in another person a reasonable apprehension of fear of that conduct. So if I tell Susie I'm going to punch her in the face, And I approach her with my arm cocked and a serious look on my face. In other words, I'm not joking. And before I get to her, Josh stops me. So I never hit her. Could I be liable for assault in that case? Yes. Why is that, Yulia? Right. And I created a fear in her that I was going to harm her. That's assault. What about if I call her up on the telephone and tell her, I'm going to punch you right now? Have I created a reasonable apprehension of fear in her? You're shaking your head no. Through the phone, right. I mean, maybe not assault. Maybe terroristic threats or something else, but not really assault. Battery, on the other hand, is a tort. That's the one we associate with, we confuse with assault. Battery is the actual physical contact with somebody else. So if I tell Susie, I'm about to punch you in the face, and I walk up to her and I actually punch her in the face, I've committed two torts. Assault, as long as my conduct put her in reasonable apprehension of fear, and then the actual battery when I contact her. So battery is defined as an unexcused, harmful, offensive physical contact that's intentionally performed. So a couple of things to appreciate here. What if I walk up behind Dez in the hallway, he doesn't know I'm coming, and I cold cock him in the back of the head and knock him out? Have I committed assault and battery? Just battery, right? Because there's no reasonable apprehension of fear. So that would just be battery. Exactly. It also could be, if I take a baseball bat to Dez, have I still committed battery even though I didn't touch him with my body, with any part of my body? That's battery. I'm still causing offensive contact to somebody else. If I run over him with my car in the parking lot on purpose, that's battery. And assault if he saw me coming. Could be. It could also, remember, these acts could also be crimes. So yeah, but remember, you're proving different things in a different court with different standards of proof. But yes, that could be. So just because I try to run you over and I miss doesn't mean I'm off the hook. I still could have some criminal liability there as well. I had something else to say about battery, but it escapes me at the moment. So I'll think about it later. All right, false imprisonment. That is the intentional confinement or restraint of another person. Oh, I'm sorry. I know what I was going to say. Let me back up for a second. Going back to the definition of battery, I said that it was an unexcused, harmful, or offensive physical contact intentionally performed. That doesn't mean that I might not be liable in a different way for hurting somebody unintentionally, okay? I don't want you to get the idea that because I didn't intend to do it, I'm off the hook. Let's say that I opened the door to the classroom after class as hard and as fast as I can, and Dez is walking this way, and I open it up into his face, okay? I didn't mean to do that. So that may not be battery, but that still doesn't mean I haven't committed a tort. It's just an unintentional tort, which we'll get to later. All right, so just because there's no intent doesn't mean it's not a tort. It just means it's not an intentional tort. We have unintentional torts all the time. People driving down the road, looking at their phone, rear-ending someone, that's not intentional, but it's still a tort. We just talk about that later. Unintentional torts, try not to confuse you, unintentional torts all fall under this idea of negligence, that someone was not exercising the degree of care that we expect a ordinary, reasonable person to exercise under the circumstances. All right, back to false imprisonment. So that was the intentional confinement or restraint of another person without justification. It could be the confinement could be by physical barriers. So I could lock you all in this room and not allow you to leave. That could be false imprisonment. It could be by physical restraint. I could duct tape everybody to their chair. False imprisonment. It could be by threat. I could have all the doors open and not tie anybody down, but have a gun right here saying anybody gets up and leaves, I'm going to shoot you. You're being confined by threat, and that is also false imprisonment. Future consequences or moral pressure is not necessarily false imprisonment. So if I said to you, everybody better stay here and not leave the room or else you're going to regret it later, that might not be false imprisonment because you might have a way to get out and get law enforcement and that kind of things when I keep you confined and you don't have other options. You hear about false imprisonment most of the time through people who shoplift and then they get detained by security at the mall or wherever, and Walmart, and they may those merchants have to be really careful about false imprisonment. They're allowed to detain somebody for suspicion of shoplifting, but they have to have a reasonable suspicion, and the confinement has to be reasonable. I mean, they can't go lock them in a in the basement of Walmart overnight or something, or lock them in a room with no light or water. Or I mean, can't do that. But you can detain someone. All right. Intentional infliction of emotional distress. Anybody ever heard of that? Not a very well-known tort, but it is one nonetheless. This happens when someone commits an act that is so extreme and outrageous that it results in severe emotional distress to another. All right, so you are the lawyer for a client who comes in and says that she wants to sue her neighbor for intentional infliction of emotional distress. What are some of the am I trying to ask? What do you think will be some of the hardest parts of you taking her case and making her case out in court? Intentional infliction of emotional distress. Got to prove it's intentional. That's right. What else do you have to prove that might be hard? That it was extreme, that there was distress, period. I mean, a broken arm, we can prove that. We got x-rays, we can get a doctor's testimony. Emotional distress it's provable. It's just not easy to prove. Some states require that, and I'm not testing you on this, but just as an illustration, some states will require that there has to be some sort of physical manifestation of the emotional distress. In other words, you can't just be mentally traumatized. It has to be showing up somehow in some you can't work, you can't get out of bed, you're taking medicine. I mean, it's they require something more than just emotional distress. Some states say if you can prove it, great. It is hard to prove, but like I said, it's not unprovable. The focus in intentional infliction of emotional distress is on the outrageousness of the conduct. And again, this is sort of a sliding scale. One little thing might not be enough, but 100 little things might add up to emotional distress. If my neighbor prank calls me, people don't prank call anymore, but that used to be a thing. Just trust me. If they prank call me in the middle of the night once, then I'm not emotionally distressed. But if they do it every night for 3 years, then I might get to the point where I can't sleep. So the one little act cumulatively could be. Similarly, if my neighbor broke in my house and put a gun to my wife's head and made all kind of awful threats, and well, she and I both might have a case for intentional infliction of emotional distress. He didn't end up doing anything; he just scared us. We might be sufficiently traumatized that we have a case just based on one act. So, a little bit of a sliding scale there. Intentional infliction of emotional distress usually comes with, it's usually not a standalone tort. It's usually something that you might throw in there with a whole bunch of other torts, or maybe a couple of other torts because of something that happened. Can't really, example doesn't come readily to mind, but you do see that sometimes. All right, defamation. This is this tort is getting a lot of play in the last few years. There have been a lot of defamation lawsuits. The one that comes to mind immediately is the one that Dominion, the people that make the voting machines, Dominion, can't remember the rest of their name, but I know it starts with Dominion, that they brought against Fox News because Fox said that there were problems with Dominion's voting machines, and this is in the last presidential election, I think, and they were false, and so Dominion sued and won like $800 million off of Fox for defamation. So let's look at what that is. It's wrongfully hurting another's reputation. Two kinds of defamation. Oral defamation is slander. Written defamation is libel. I do want you to know the difference between those two. Libel, written defamation, can be, obviously, if I write a sentence, an email, a book, a newspaper article, but it could also be a text, it could also be a picture. All this is in writing, and it can be disseminated. Oral slander wouldn't necessarily be disseminated because I've said it once. I guess if it's recorded and replayed, that might become libel at that point, but not going to get that into that much of a distinction for you. So what do we require if we're going to prove defamation? We got to prove four things, and then I'm going to break these down as we go. A false statement of fact. The statement has to be about the plaintiff, and it has to harm the plaintiff's reputation. It has to be published to another other than the person being defamed. And then if the person is a public figure, you got to prove something called actual malice. So let's go through those. A false statement of fact. Caleb, if I say to the class that I think that your family's business is, in my opinion, the worst run business in Harris County, have I committed defamation? Did I make a false statement of fact? All right. What if I said, well, I know you do because I've offended you. What is the difference then between me saying, my opinion is that your company is trash, versus saying your company is trash? An opinion is not defamation. An opinion is not defamation because we have a First Amendment right to speak our minds. But there's a fine line there. So you made a good point. I spoke it like a fact, didn't I? Even when I took out, in my opinion, if I just said, your company is trash, which it is not. Of course, this company is not trash, or I wouldn't be using this example. I still might have a decent defense in court that all I said was his company is trash. That's just my opinion. Saying his company is trash is hard to prove. Now, if I said something like, your company is crooked, that's a little bit of a different story, because now the word crooked implies you're breaking the law somehow. Yeah, now if I'm really specific and say your company doesn't pay dodges taxes, or cheats taxes or something like that, if it's provable, or non-provable, then you get into fact. But I said that to just demonstrate to you it's a fine line between opinion and fact. I can't say something factually wrong about you and then say, but that's just my opinion. If I can't say, for example, your company is crooked because you guys don't pay taxes, you cheat the IRS, you are tax criminals, in my opinion. I mean, that might not fly. Fox News was reporting that that Dominion, and I could look into it a little more, but yeah, they're going to be held to a higher standard because they're broadcasting the news. I might be held to a lower standard. Maybe I'm a disgruntled customer or something, and I'm just going off on your company, but it's really that I'm just mad at you and don't like you. Maybe not as defamatory. Also, go back to what I said at the beginning about who sues for tort. The people that actually go to court and sue somebody for a tort are the people that have something to recover. So if I told the class here that in my opinion, your company is trash, you're not going to sue me for that because I mean, what harm to? How are you going to prove the harm to your reputation? You know what I mean? Yeah, it's not as what's the word I'm looking for? It's not as easy to calculate the harm I've done. Same thing if I said your company is crooked and y'all don't pay your taxes. I mean, if I just said that to the class, I might have made a false statement of fact. I might meet all of these requirements for defamation, but you still might not sue me because what's it worth to you? So again, going back to what constitutes defamation, we remember that's a different thing than if you would actually sue for it. If I make the false statement in here about his company, a false statement of fact, and it meets these other things, I've defamed him. But whether he's going to sue me for it is up to him. All right, so a false statement of fact as opposed to an opinion. The second requirement is it must be about the plaintiff and tend to harm their reputation. Pretty self-explanatory. The third thing of proof is that it has to be published, and by published, I mean communicated to another person, not like published in writing like in a book, like we'd normally think of publication. Publication in the legal sense means it got said, read, communicated to another person. Yeah, that is absolutely published. And it has to be to somebody else other than the person that I'm trash talking. So if after class, me and Caleb are the only ones in here, and I go off and say a bunch of false trash talk about his company, I have not committed defamation because my statements were not published to a third party. If JJ was standing outside the door and overheard it, though, now my statements have been published to a third party, and I have defamed him. So it has to be published to another person other than the plaintiff. All right, those are the basic three requirements of defamation. And then if the person that is claiming defamation is a public figure, then there's a fourth requirement, which is actual malice. And that means the person has to know it was false and intentionally do it anyway. That is, I'm not a public figure, so I don't know what that would be like, but I would imagine that would be very frustrating to a public figure that people could just talk trash about them and it not be defamation most of the time. But at the same time, from a standpoint of First Amendment, freedom of speech, communication, people who are public figures put themselves out there and they are, to some extent, they're in the public eye and they're subject to a little bit less leeway than we would afford a private citizen when it comes to defamation. So they can still sue if somebody said something wrong about them. They just have to prove that it was wrong. I mean, the person knew it was wrong and did it anyway. As opposed to like me retweeting something bad about Taylor Swift or repeating something I heard on the news or something. I mean, it might end up being false. It might end up that I published to somebody else. It might end up being about the plaintiff, but I didn't have actual malice. I was just repeating something I heard. I didn't know that it wasn't true. It's pretty hard for a private citizen to get sued for defamation when it comes to a public figure, because the private citizen just doesn't have the ability, capacity, resources to disseminate it widely enough to harm the person's reputation, I would say. But I could still see that happening. I can conceive of scenarios where that would happen. But it's easier for a public figure to sue like the National Enquirer or People Magazine or Fox News or something like that, because they have a little bit higher standard of checking what they say or report. All right, so that's kind of how defamation is laid out. Your outline talks about, it's a little confusing. It's a little bit harder to prove damages for slander than it is for libel. And that's because, remember, libel is for written defamation. So it's a lot more likely that something that's put in writing is going to get spread widely than it is for something that's spoken. And so it's a little bit harder to prove damages in slander. So my example about why Caleb probably wouldn't sue me for saying his company cheats on their taxes is because I said it to you 10 and you guys aren't customers of his. You don't, I mean, there's not likely to be any damage to him. I mean, I've slandered him, yes, but I don't have the capacity to create as much damage with slander as I do with libel. If I put it in writing and it gets retweeted or goes viral or something like that, then my written defamation has a lot more capacity to do damage to him. There are some. I always think this is funny. This is kind of ancient law that still exists, but it's not really used much anymore. Your outline says that if someone slanders you for these 4 things, you don't have to prove special damages. It's just assumed that the person was damaged. And remember, we're talking about slander, so spoken. So a statement that a person has a loathsome disease, like an STD, or, I mean, there used to be some diseases that were, well, I'll give you an example. When I was little, AIDS, HIV was, when it just came on, it was perceived as mostly a homosexual disease, and it had a terrible stigma, and associating that with people was a big deal back then, or caused more harm than it would be today. So that was, I'm having trouble thinking of a loathsome disease today. I mean, STDs, I guess, alleging someone's mentally ill, things like that, I can see. But loathsome disease, you don't have to prove special damages. A statement that a person has committed improprieties while engaged in a profession or trade. So that might qualify for what I said about his company, that he might not have to prove special damages because I've alleged that he's crooked in his business. A statement that another has committed or been in prison for a serious crime. If I told y'all that so-and-so was a convicted rapist, and then that word spread and that was untrue, that person wouldn't have to prove special damages against me. Or if I make a statement that an unmarried woman is unchaste, that is still built into the law. I think that people make disparaging comments about others all the time that, for better or worse, that still shouldn't be okay. But our tolerance for what people say is unfortunately gone way down. I mean, way up. All right, so defenses to defamation. So obviously the truth is a defense to defamation. Oh, I know another. We might have talked about this, but the Trump case, where he said some bad things about that writer, Jean Carroll, and she sued him for defamation. And he didn't even bother to participate in the trial or anything, but the jury found him liable. Remember, not guilty in tort, it's liable. They found him liable and they awarded her $5 million in damages, several $1,000,000. And then he said something defamatory about her after the verdict, but the case was still open and she amended her complaint, and now the judge has said he's got to answer for that too. So that case is still going on. All right, defense is truth. Yeah.
If found not guilty in that first one, this was close and you said something again, you can try it again.
Yes. So it's not like double jeopardy in criminal law, where if you're found not guilty, you can't be tried again. He could not be, she could not sue him again for defamation for the things that he was found not liable for. But if he said something else about her afterwards, then she could sue him for defamation on that. Yeah. 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 I mean, she probably wouldn't, because she'd already put it in front of a jury and they'd said no, but she could. But the question was, could she? And yeah, the answer is yeah. Some communications are privileged, and so they would not be subject to defamation. Statements made by lawyers and judges in a courtroom during a trial or by government officials during a legislative debate, those are not defamatory. But that rarely comes. I don't know that I've ever heard of anybody using the courtroom statement privilege as a defense to defamation. But I certainly could see where it could happen. All right, let's go to invasion of privacy and appropriation. So your outline lists 4 different acts that qualify as a tortious invasion of privacy. In other words, these 4 things would constitute torts. Intrusion into an individual's affairs or seclusion. So invading someone's home, illegally searching someone's belongings, eavesdropping by wiretap, window peeping. These all sound like crimes, right? Because they are, but they're also torts. And you could also sue the person who did that for invasion of privacy. False light, that is publishing information that places a person in under a false light. So like if the newspaper, if the Ledger Inquirer publishes a headline on the front page that says, unknown man spreading STDs all throughout Columbus or something like that, and they put a picture of me there. They don't name me or anything, but they, it says unknown man. I could sue them for the tort of false light. They have portrayed me in a false light. Now again, truth would be a defense to that. So I mean, if I am the person that's doing that, then I could not sue them for false light. Only if I'm innocent, which of course I am. Public disclosure of private facts, like revenge porn, revenge anything disclosure of stuff people that's intended to be private, or things that an ordinary person would find objectionable. That's public disclosure of private facts. And then appropriation is using somebody else's name, picture, or likeness for commercial purposes without permission. So if Dan uses, I don't know, a famous kayaker in his advertisements without permission, he has permission. So he's doing some things right.
Yeah.
All right.
Based on one national.
But he gave him permission. If he didn't get permission, do you think Dan would have used it anyway? So that's appropriation, using somebody else's identity. And it doesn't have to be a famous person. I mean, he could use JJ's picture on an advertisement without his permission, and that would still be appropriation. Fraudulent misrepresentation. So fraud involves, remember we're talking about intentional torts today. So intentional deceit for personal gain. A person intended to lie about something in order to convince, provoke, cause someone else to do something. So the elements are going to be misrepresentation of facts or conditions with knowledge that they were false or reckless disregard from the truth. Remember, if I make a statement and I believe that it's true and have a good faith basis for that belief, I haven't intentionally deceived the person. I haven't committed intentional fraud. There are some frauds that I still might be liable for unintentionally, but we're talking about intentional today. So misrepresentation of facts, knowing their faults. Intent to induce another to rely on the misrepresentation. Think a private sale of a car. I'm going to sell my Bronco to Caleb, and I tell him that it has never been in a wreck, and I know it's been in a wreck because I wrecked it. So I've intentionally made a misstatement of fact to him. And the intent of me making that statement is to induce him to rely on it in buying my car. He has to have justifiable reliance. He has to have damages. And there has to be a connection between my misrepresentation and the injury he suffered. So let's walk through that a second in some ways ways we might not have fraud. If I tell Caleb that the Broncos, that I believe that they're going to stop making the Broncos, and I know that's not true, I guess I might be saying that to induce him to rely on that. Would that be justifiable for him to rely on that statement? Probably not. It'd be something he could easily find out. It doesn't make common sense. So his reliance might not be justified in that case. If he is 16 years old and has some sort of developmental disability, then his reliance might be justifiable. He might not have the capacity to know that what I'm telling him is wrong, or to know that what I'm saying is likely BS. So it has to be justifiable, and that would depend on a case-by-case basis. And then he also has to have damages. So if I tell him that my Bronco's never been wrecked, and I'd say that to him so that he buys the car, he ends up backing out and not buying the car, he doesn't have any damages. He backed out for another reason. His financing didn't come through, or he decided he didn't like the color, or his wife told him he wasn't allowed to buy it. Then there's no damages. Nothing's happened to him. Again, we get into a little bit of statement of fact versus opinion here. So as a person selling something, I'm allowed to say things like, this car it's the best running car I've ever had. You're going to love driving it. I can say things like that. This is the best car out there for safety. That's an opinion. Maybe if I told him that multiple Consumer Reports studies have shown that it's the safest car out there, and that's not true, that might not be opinion. But Salespeople are allowed a little bit of leeway when it comes to fraudulent misrepresentation. Your outline lists negligent misrepresentation. That's for next week. Negligence, again, is an unintentional tort. And so that can also be something that I'm liable for, but we'll talk about that later. Abusive or frivolous litigation. So we have a right as citizens not to be sued without a proper reason. Somebody can't just file lawsuits against me to harass me or to make me spend money on lawyers or to make me spend time in court or to harm my reputation. There has to be a basis for it. Now, it's a pretty low bar, okay? Just because somebody files a lawsuit against me and they lose the lawsuit, that doesn't mean that they've committed frivolous litigation or abusive litigation. It has to be something that is so baseless that the only reason it's being done is for harassment or abuse or something like that. If you've got a legitimate claim or even a semi-legitimate claim, it's not going to be abusive or frivolous. Wrongful interference is an intentional tort that I want you to be aware of. It has to do with a contractual relationship. So there has to be a lawful contract in place, and a person has to intentionally cause that contract to be broken. Let's say that JJ hires Dez's construction company to build his business's building, and I know that they have a contract for that, but I want to I want to build that building, and so I go in and I talk to JJ and convince him that I can do it cheaper, and tell him bad things about Dez's company, and just basically make it so good of a deal that he breaks his contract with Dez. If that was the intent of my action was to cause him to break that contract and go with me, then I might have committed the tort of wrongful interference with contract. If Yulia has an employment contract with her employer and I go in and convince her to come work for me, I know she has a contract with that employer, but I'm making her a deal that she can't refuse, then I might have wrongfully interfered with that contract. That doesn't mean now that she can't apply for a job that I have open, or she's free to look for more work. And if she applies for my job and I hire her, I haven't interfered with the contract because I didn't intentionally do anything to her employer. She came to me and applied for my job. But if I went to her and was like, I want to hire you away from that employer, what will it take? She gives me a number and I say done, then I had the intent of her breaking that contract. One thing that a difference we need to appreciate when we get to the tort of wrongful interference is that competition is not wrong. So although I can't interfere unreasonably with another's business, I can still compete with them. Advertising is not wrongful interference. Slashing prices is not wrongful interference. Sending out mailers to the general public is not wrongful interference. That's lawful competition. I'm allowed to do those things. Whether it's just competition or whether it's predatory and therefore tortious depends on whether a business is attempting to attract customers in general, advertising and marketing, or to solicit only those customers who have a relationship or have shown an interest in a specific competitor. That might be wrongful interference. So it's the nature of the conduct. Is it general marketing advertising, or is it targeted to specifically siphon off or steal customers or divert customers from one business to another? In that case, it might be wrongful interference. So it's not just with, I talked about wrongful interference with a contractual relationship. We can also have wrongful interference with a business relationship between business and customer. No contract there, but there's a business relationship with the customer. All right. Intentional torts. Those were all intentional torts against a person. So I want to move to intentional torts against property. I'll try to do this in 15 minutes we've got left. But if I don't make it through, that's okay, because we'll take it up on Thursday. I think I do want to take this up on Thursday. I think that's a good stopping point for today. So Thursday, we're going to talk about intentional torts to property. We're going to talk about the Dykstra versus Darling case. That's a baseball case, JJ, so I'm going to call on you for that one. And everybody else too. Dykstra versus Darling. Lynn Dykstra versus Ron Darling. Defamation. It's old. I mean, it dates me. But basically, Ron Darling published a book, and he said he trash talked Lenny Dykstra, and Dykstra sued him for defamation. So we're going to go through that case on Thursday, and then I have a tort fact pattern that we're going to go over on Thursday, but you can read that ahead of time, or else I'll give everybody 5 minutes to read it. It's a short paragraph. You can read that at the beginning of class on Thursday. All right, let's leave it there. See y'all Thursday.